Good morning. I hope I'm heard well. My name is Anna Kosińska, and this is my honor and pleasure to open in the name of the Dean of the Faculty of Law and Administration of University of Szczecin the first English-speaking panel on this conference, which is dedicated to the problem of legal theory in European academics research process. Let me introduce our speakers. It is also a moment for me as a moderator to check whether all our professors are present with us. The panel starts with the speech of Professor Reinard-Sieckman on the dimension of law. Then I would like to welcome Professor Kiritsis Dimitrios from the University of Essex, Professor Claudio Michelon from the University of Edinburgh, Professor Paolo Di Lucia and Professor Lorenzo Paserini Glazel from the University of Milan from Italy, Professor Emilios Christodoulidis from the University of Glasgow, Professor Corrado Roversi from the University of Bologna, and Professor Anne Wagner from the University of Lille, France. I would like to ask whether Professor Sieckman is with us, because it is the time to start the first speech.
Yes,
Good morning.
hello. You
This is
can
my
hear me?
great pleasure to host here the professor. Please, this is your time to present the speech. We are prescribed of the time, and the time for the speech is 20 minutes.
Well, thank you very much for the invitation, for giving me the opportunity to present here my ideas on concept and understanding of law and jurisprudence. Well, the title of my speech is Dimensions of Law. The background feels is that there's not one single concept of law which explains everything, but law is a complex phenomenon which cannot be grasped by one single concept of law, but we need or can have different conceptions of law. For example, law as an empirical phenomenon is not identical with law as norms used to justify legal judgments. In particular, I will distinguish three distinct approaches to the phenomenon of law: law as a legal system, law as a normative reason for legal judgments, and law as a legal practice. Law as a legal system consists of a set of norms derived from certain criteria of legal validity. Law as a normative reason is characterized by the implication that it ought to be applied and followed by its addressees. And law as a legal practice consists of a set of interrelated legal judgments which apply legal norms or other views. One might describe these aspects as the analytical, the normative, and the empirical dimension of law. My aim is to describe these dimensions and explain some relations between them. So the next point is the analytical dimension, law as a legal system. Now I have a PowerPoint presentation which I would like to share. Here is it. Yes. And now, yes, the analytical dimension, law as a legal system. Law as a legal system is defined as a set of norms identified by certain criteria of legal validity. Legal norms are constituted by norm-creating acts grounded on legal competences and competence norms, at least if this is the main source of law. The structure of such competence norms may be described as: if the competence to create a norm is correctly exercised regarding a norm N, then N is legally valid. Well, you find on the PowerPoint presentation a formal symbolization of this basic structure of competence norms. The identification of law at this level is primarily a matter of description and logical inference. One must identify the competence of some legal organ to create a legal norm according to a competence norm, then state that the conditions of a correct exercise of the respective competence are met, and finally infer the legal validity of the enacted norm. One should note, however, that legal norms are considered as normatively valid. That is, that at least in principle, the addressees of the legal norm ought to accept it as valid and apply or follow it. Hence, law as a legal system already has a normative dimension. This implies that the consequence of the correct exercise of a legal competence to create a norm is not merely legal validity of this norm in the sense of membership in a legal system, but also the demand that this norm ought to be applied and followed. Hence, we must accept also a normative statement together with a competence norm, that if the competence to create a norm is correctly exercised regarding norm N, then N ought to be applied by its addressees. That is the second formula here on the PowerPoint presentation. Such a statement presents a norm and hence requires a normative justification. A normative justification must support the conclusion that one ought to accept the respective norm as valid. Hence, we need also a conclusion of the form: one ought to accept that if the competence to create a norm is correctly exercised regarding norm N, then N ought to be applied and followed by its addressees. This third formula explains this normative conclusion, which presents a justification for accepting the exercise of the result of the competence norm. So we have here an obligation or ought to accept to recognize and respect the respective legal competence. Now, whatever the justification of this requirement might be, of course, we need some justification for this requirement. It will have the structure of a general requirement to accept the respective competence as valid. I suggest to call such requirements formal principles. Formal principles, hence, require that the norm established by means of some competence ought to be followed, and accordingly that the respective legal competence ought to be recognized. This is to say, the normative claim connected with legal competences is contained in formal principles. And since the authoritative character of law follows from the existence of competences to create legal norms, formal principles, one can say, constitute the authoritative structures in law. This leads to the thesis that an essential element of the analytic dimension of law are formal principles. Hence, formal principles constitute a necessary element of legal systems which distinguishes law from morality and complements the hierarchical structure of legal systems that results from the derivation of legal norms from criteria of legal validity. That is the dynamic dimension of law according to Kelsen. But we need also formal principles which complement this structure. Now, since formal principles appear to be an essential element of law, they deserve closer examination, but here is not the time to go into this subject. Therefore, I directly turn to the second dimension, which I will discuss, the normative dimension of law. That is law in the form of normative legal judgments. The normativity of law is included in the characteristic that legal validity of a norm implies a demand that this norm ought to be applied and followed, as already in the analytic dimension, law as a legal system. But one might say that law claims normativity. Of course, single agents, but one can say law claims normativity. However, law can claim normative validity only if such claims are not only raised, but also justified. Therefore, law must comply with certain normative requirements. These requirements must be met in order to justify that one actually ought to apply or follow the law. Hence, the issue is what is required to justify legal judgments. This issue must be dealt with from the perspective of someone forming legal judgments, that is, from the perspective of a participant of the legal system. The definition of participant of the legal system is exactly that he forms legal judgments on his own. Hence, the normative dimension of law must be analyzed from the perspective of the participants of the legal system. Now, the participant's perspective is not does not differ from the observer's perspective as long as we have only one unique legal norm that ought to be applied. But the participant's perspective gains importance in case that conflicts occur within a legal system or between competing normative systems. From this perspective, in first place, the authority of law must be recognized as an argument from the perspective of a participant. Now, if positive law provides a unique answer, legal judgments from the participant's perspective will not differ from the perspective of an observer. In contrast, the participant's perspective becomes relevant where legal claims encounter conflicts. Positive law might have internal conflicts, or it might conflict with normative requirements of, for example, political morality or of some other legal system. In case of conflicts, respect for the authority of law cannot be demanded unconditionally. Participants of a legal system must balance the authoritative claim of their system with competing normative demands. As a consequence, a crucial thesis regarding law from the participant's perspective is that, in principle, a demand of correct balancing of legitimate normative claims must be recognized by the participants of a legal system. Such a demand of correct balancing, hence, is a fundamental principle of law, which, for example, is expressed in the principle of proportionality, which again is a topic which we cannot enter here. Now, but what should be said is balancing presupposes a conflict of normative demands. Hence, on the one hand, we have the authority of law, the formal principles which require respect for the authority of law. But on the other hand, the question is, what are the normative demands that could conflict with the authoritative claim of law? These must be claims that are not, again, grounded on positive enactment, but must necessarily be recognized as legally relevant principles. In first place, such principles are human rights principles. They must be recognized within legal systems, irrespectively of whether they are positively recognized or not. Each legal system must hence recognize such human rights principles as valid in a normative sense. Hence, further thesis is that normative validity of law implies the recognition of certain human rights principles. Which principles must be recognized as human rights principles is an issue on its own, which we cannot discuss here. But one might well assume that there are at least some human rights principles that must be legally recognized if the normative claim of law should be justified. One should note, however, that the balancing of legal principles by some participant does not yet justify a statement that the norm proposed by the participant as a result of its balancing is actually legally valid. That is because an individual participant can only claim that a particular norm ought to be accepted as definitively valid, but an individual normative judgment cannot determine the legal situation because other agents have the same claim to make, and in this potential conflict with other individual normative judgments, no one can claim that his judgment will determine the legal situation. Therefore, a statement of legal validity requires more than an individual normative judgment. There must be some kind of objective validity of a normative judgment. This objectivity might result, for example, from a justification that is rationally necessary, for example, necessary to recognize human rights, or it might result from some competence, for example, of a court to state its own normative view as legally valid, or from support by a legal practice. Now, legal practice, this is the issue to which we turn next. The third dimension of law, which I will discuss here, the empirical dimension. The interrelated individual normative judgments of agents in a legal system make up a legal practice. Legal practice is, in first place, an empirical phenomenon. It is possible, to some extent at least, to identify what the judgments and activities are that constitute a legal practice. However, as a legal practice, law cannot be a purely empirical phenomenon. The point of the practice is to determine what are the legally valid norms and how cases ought to be decided according to the law. In the end, legal statements regarding a legal practice are normative. In this claim to normativity, statements of what is valid according to a legal practice resemble the normative claim already included in individual legal judgments of the participants of a legal system. However, acting within a legal practice changes the issue of legal judgment. The question is not what is the normative view of the individual agent, but the question is what is required according to the legal practice interpreted in a correct manner, respecting moral requirements as far as possible, but accepting the existing legal practice as authoritative. That is, the question is how should one correctly decide within a legal practice? In contrast, the individual normative perspective asks how should one decide morally correctly facing the existing legal practice. The individual normative judgment might, however, demand to reject the legal practice, problem of extremely unjust law. On the other hand, if law is regarded as a legal practice, the existing legal practice is the frame in which the argument about what is law must take place. The issue hence is the interpretation of a legal practice. However, this interpretation requires balancing. I have tried to express this in the PowerPoint. Interpretation must present arguments to decide a disputed issue, and as these arguments collide, balancing will be necessary. Balancing and interpretation, hence, are not incompatible. The legal practice is the frame in which balancing takes place. This balancing interprets the legal practice, hence the interpretation of legal practice requires balancing. Now, the legal practice consists of numerous interrelated individual judgments, which result from the balancing of legal arguments regarding the interpretation of the legal practice. And the point and the difference to the individual normative judgment in the normative dimension is that this balancing considers the issue of what is the correct result of a balancing between this diverging or different individual normative judgments. So it is not first order balancing, but second order balancing, which considers also the individual judgments of other agents on equal footing. Now I come to my conclusion. We have to distinguish hence various dimensions of law, the analytical, the normative, and the empirical dimension. Each leads to a particular concept of law, but these are interrelated. None of them presents in itself a complete view of law. The conception of law as a legal system must include the normative claims raised by the participants of the legal system, and this requires at least the recognition of formal principles as a justification of legal competences. Also, it presupposes a legal practice in order to identify the ultimate criteria of legal validity of the legal system. Well, I haven't mentioned it in my talk, but it's also a relation between the systemic and the empirical dimension of law. Now, the participants' conception of law addresses the issue of which norm ought to be regarded as legally valid in order to justify a legal statement, legal judgment. This judgment is normative, but depends on the systemic validity of norms, as well as the legal judgments of other participants in the legal practice. Nevertheless, its normative claim cannot be justified by mere reference to systemic validity or legal practice. And thirdly, the legal practice includes the legal judgments of its participants, but also must be considered by the participants in their legal judgments. In the end, it cannot replace the normative judgments of the individual participants, but also is different from an individual legal judgment. So this is my conclusion. Thank you for your attention, and thank you very much.
Thank you very much, Professor, for this very interesting for me personally lecture on the concepts of law. I found very interesting the conclusions that none of the concepts is presenting the complete view of law, and they are interrelated. And it gives me a presume that these concepts are quite similar to the concept of the doctrine of human rights, where also all they are interrelated and cannot be completed together. I hope that this speech is going to be deeply discussed during our time of the discussion. And now it is